Welcome to FDVN's channel. In today's video, we will introduce the new lesson, Copyright and Patent. 1. Reading Comprehension. Copyright. Trainees at a law firm have been asked to help prepare a section on intellectual property, IP, law for the monthly e-newsletter circulated to clients. Some of their preparatory notes are below. Type of IP interest, copyright. How the interest or right arises, an automatic right arising from statute. Copyright arises as soon as an original work is created and embodied in a specific media, for example on film, in a sound recording, in print, or as an electronic record. Copyright also arises in the typography, the layout, of the published works. What protection is available? It is the expression in a particular tangible form which is protected rather than the idea itself. The copyright owner, normally the author, has exclusive rights, including the rights to make copies, to sell copies to the public, or to give a public performance of the work. The owner may license, usually in writing, the reproduction of the work. Action required. The right cannot be registered. It is possible to use a copyright symbol, copyright, followed by the author's name and date to indicate that it is intended that the work should have copyright protection, but it is not necessary to do this. 2. Patent. Type of IP interest. Patent. How the interest or right arises. A patent is a territorial right given to the patent holder for a statutory period of years. It must be applied for in each jurisdiction for which protection is required. To be patentable, an invention must be novel, that is, not made public anywhere before the filing date on which the application/description is submitted for patent. Be capable of industrial application, that is, use or application in some kind of industry, for example be a process, a material, or a device. Result from an inventive step. In the US, the test is to be non-obvious, that is, be something distinctive which could not have been produced by anyone with relatively good knowledge in the relevant area. Not be an excluded thing, as such, Patents Act 1977. For example, it cannot be a discovery, a scientific theory, an aesthetic creation or, in the UK, a business method. What protection is available? The invention becomes a property interest vested in the inventor, which she can transfer, by assignment, to another. It confers the right to exclude others from making, using, or selling the invention. The import into the UK of a product with a UK patent will be in contravention of the patent. Action required. An application should be filed on the Patent Office before any steps are taken to make the invention public. A patent application may fail or the grant of a patent can be revoked, that is, removed from the register in terms of the Patent Acts 1997, if, for example, a successful application is made to the court in counterclaim on grounds such as the invention is contrary to public policy or morality, for example, human cloning processes, or the person granted the patent does not have entitlement to it. 2. Practice. 2.1 Make adjectives from the nouns in brackets. Put a stress mark in front of the stressed syllable in each adjective. Look at A and B opposite to help you. 1. Patent holders have territory, rights over their inventions. 2. Copyright is a statutory right in an origin work. 3. A number of rights fall within intellect, property, including copyright, design, patents, and trademarks. 4. To be patented, an invention must have some sort of industry use. This might include, for example, in agriculture. 5. Discoveries of elements of the human body are not patent. 6. The invention has to be novelty, and must not have been disclosed before. 2.2 Listen and fill in the missing words in the blanks. 1. It is essential to identify the first copyright owner, before determining whether a particular form of work qualifies for protection. 2. The duration of copyright protection is calculated by reference to the author of the copyright work. 3. Copyright arises in product design and in the presentation of merchandising for products like toys and cosmetics. 2.3 Complete the definitions. Look at the table below and choose the correct answer. 1. A property right that subsists in certain rangeable creative works. 2. A right that exists as soon as a work that can be protected by copyright is created in material form. 3. The transfer of IP. 7. The criterion for assessing whether an invention is not an obvious development of what has been done before, in the judgment of someone who is skilled in the relevant area. 8. Not having been disclosed anywhere else in the world before. 9. The capacity of an invention to meet the criteria set by statute in order for an application to be granted. 2.4 Choose the correct phrase in brackets to complete the sentences. 1. The Act generally gives the owner of copyright exclusive rights to reproduce the copyrighted work and to perform the work publicly. 2. The patent gives the right to exclude others from importing the invention.